Fire companies responded to put the fire out. Nobody was hurt. A suspect has been arrested after 3 people were shot, 1 killed at the Cityco on Glenwood Drive. Jacoby Jordan taken into custody. Police say the teenager shot 1 man and killed him and then injured himself in the process, taking himself to the hospital. 1 victim died, 2 others injured. Russell Stroud, Nooga Radio News, now.
In-depth traffic, news, and information. Mornings on Nooga Radio, AM 1240 and 92.7 FM.
Expect partly cloudy and pleasant weather out there through your afternoon. Could see a little spotty shower pass through, but not much. Highs 80 to 83. Tonight, clear, comfortable. Some late fog, lows upper 50s. For Wednesday, lots of sun, warmer highs mid and upper 80s. Scattered showers and thunder showers later Thursday. Celebrate the 4th with Dixieland Fireworks. Locally owned with the largest and newest selection around. A Black Cat dealer with the lowest prices in Dixie. Dixieland Fireworks, just off I-75 on Ringgold Road, East Ridge. And I'm Storm Team 12 Chief Meteorologist Patrick Ford. On Nooga Radio, AM 1240 and 92.7 FM.
The Tennessee Valley's news, talk, and sports leader. Nooga Radio, AM 1240 and 92.7 FM.
Good morning, Chattanooga. This is Jim McCoon, and welcome to Legal Bytes. I have with us today is our guest and co-host, Trevor Ashley. How you doing, Trevor?
Jim, doing fine. Thank you for having me.
And what wonderful weather it is out there today. I mean, for the past several days, you can really tell summer is here, and it is just really nice.
We've been very fortunate. It's so pleasant this morning. Low humidity. A lot of times in the summer, the humidity gets so high, we walk outside and it's like you're walking into a sauna. But this morning, it just felt wonderful.
I know, and something that happens every year when summer comes in strong and people start traveling is we always see a spike in estate planning. People are traveling and going different places, and they're worried about leaving behind either loved ones that may not be going with them, where mom and dad maybe are going on a trip, or they're worried about their property and what's going to happen and what may happen to them if they get hurt somewhere, especially going out of the country. So we end up getting phone calls, and I know you've experienced that, where people say, we're leaving on Friday. We need you to review what we've got and help us try to address some of those issues before we hit the road.
That's absolutely true. And it a lot of times comes up in the circumstance of a young family that has young children, and they're concerned about ensuring that if the parents, or something happened to them while they were out on vacation, that there's a plan in place to take care of their children. And it also happens with folks whose children are grown and they're traveling, and they want to make sure that if they pass away, that there's a plan in place regarding the distribution of their property upon their death.
Agreed. In fact, I just recently had a young businessman and his wife. They were going away on a business convention, basically, that was being provided, where his company, because he was one of the lead producers, was sending them down to the Caribbean. And they had small children at home, and they were concerned about what if something happened. They've seen all the news articles about what occurs when you leave the States. And so they wanted to address how their children would be taken care of, who would take care of their children, and the like before they left the country. And so that was something we had to get together with them real quick in less than 5 days and try to address.
That's a very quick turnaround.
Yeah, well, it's one of those where the wife suddenly, I think she'd been thinking about it as they planned the trip, but I don't think it ever reached a boiling point for her or her husband until they got within that week before they were leaving. And then she just was absolutely insistent that we address these concerns before they leave the borders of the United States, and appropriately so, I have to say. And so we did address those issues, and so they had a much more pleasant time as they left, and I think they're back now. And I think that, what they've got in place will not only serve that purpose, but will continue to serve their purposes until more children or till their estate alters because of accretions in value and the things that they may do in their lifetime. So, but those out there in the public that are listening, if you have questions about what's going on in your state, or if you're planning a trip and you want to call to discuss some of your concerns, our number here at the station is 423-800-8949. We'll be happy to take your calls here on Nooga Radio, AM 1240, FM 92.7. And Trevor, I know that this is something that you do a lot in your everyday practice, is estate planning and addressing various powers and what needs to be done. When you get a phone call like this and you've got a couple and they're younger, they're not looking at ending their lives in any, future time in this up and coming, and they've got young children, what are some of the first questions you ask as far as what they've addressed before they do something like this?
Well, particularly with young children, you want to have just a very candid discussion about whom they might want to nominate to serve as a guardian for their children, which would be somebody they would nominate to take care of the children, make medical decisions for them, make decisions where they're going to reside, decisions where they're going to attend school, things of that nature, and then also discuss with them who they'd want to manage their children's property. And this would be a trustee that would be appointed and be created in some testamentary instrument or in some inter vivos trust, a living trust, to manage property for the children.
Right. And the person who's over your will, such as an executor or an executrix, whether it's man or woman, is not necessarily the same person that you want to serve as trustee over the assets that are allocated for your minor children.
That's absolutely correct. And there's a couple of factors to consider there. One is the person serving as an executor of your estate is going to serve sort of on a very finite basis. It's going to be from the beginning when you start the probate administration to where you make final distributions at the end. And that typically lasts anywhere from, it can be as short as 4 months, typically takes 12 to 18 months for that process to work. The trustee, on the other hand, depending on the age of your minor child, is going to serve for a number of years.
Sure. I mean, you're looking at 14, 16 years
possibly. And the trust can continue to exist beyond a child's 18th birthday. So you could provide that it will, be held in trust until the child graduates from college or until the child reaches age 25. Or you could have a situation where you have partial vesting at different ages. So at 25, the child gets one half of the value distributed outright free of trust, then to the adult, and then a second vesting age at 30, where at 30 they get the remainder.
Sure. Or you want to set up so their college education is funded at 18 and do it in dough balls, as we say in South Georgia, dough balls. Do it in allotments of cash to pay for education, then maybe to help them with their first home, and then at a point in time when you think they're mature, but keeping it protected because you want to stay in trust, because candidly they are at an age when they're not mature and they could either be spendthrifts and go through the money too quickly, or they can make mistakes, car accidents.
That's right.
Relationships and the like, where suddenly those funds you intended for them aren't available for them because some third party has been able to tap them because of a claim.
And so in these types of trusts, I'm glad you mentioned that, you almost always include what's called a spendthrift provision.
Teach me, what is the spendthrift provision?
Well, spendthrift is sort of, I guess, a legal term for somebody who spends money carelessly. And a spendthrift provision provides that money held in trust will not be subject to claims of creditors of the beneficiary, and it restricts the beneficiary from demanding payments from the trust or being able to assert any control over the funds held by the trustee. And the purpose of that is to protect the funds either from a beneficiary who wouldn't spend the money wisely, but also
a child.
Correct.
Keep it in the situation of a child,
not
just a general beneficiary.
And even after he reaches the age of 18, because as probably many listeners are aware, 18-year-olds typically are not very good at handling money. so you want often the provisions of the trust to continue beyond the child's 18th birthday. And you're talking about, for example, planning for college. You might include instructions to the trustee that the trustee is authorized and directed to pay tuition to whatever college institution the child attends, but not necessarily make distributions directly to the child.
Right. Exactly. You can fund room and board and tuition, but you may not be able to provide weekend money and those kind of things.
That's right.
Or provide a car. You may want your child to actually have to earn certain things in life if you're no longer here to learn the lessons that they'll need later.
And that's probably one of the hardest decisions, particularly very wealthy people have to consider. Warren Buffett's talked about this. How do I provide for my children in a way that doesn't turn them into sort of a typical trust fund type situation where they don't develop a skill set necessary for everyday successful lives?
Right. And I know that one of the things that I've seen is where they basically have awards or bells and whistles that the child has to achieve in order to get the next allotment, so that, they get, X dollars at age 18 as kind of a gift. And then the trustees authorized to fund education. And if they complete their education usually within 6 years, they don't hold them to 4 years, but if they complete their education within 6 years from a college or other institution, then at that point they get another allotment, and it's put out there. Otherwise, the funds stay in trust. And while the child will never want, their needs will be taken care of, but their wants won't be taken care of. There's a real difference there.
Oh, there certainly is. And the child won't be able to, you're kind of talking about a carrot and stick situation there, where you're using distributions from the trust to incentivize the child to accomplish things that the parent normally would be there to encourage the child to do. But the parent in our hypothetical is deceased, and we've created this trust for the benefit of their child. So now we're using this trust mechanism to essentially provide a way for the parent to try to help the child do things that he normally would have done if he were still alive.
And, while these are very complicated issues and concerns that you have for your child as you're planning what to do in your estate, as you're getting ready to go on vacation or leave the country, or maybe just sitting down and decide it's time to make your plans. This usually is not the one that's the most difficult or the one that takes the most time. But what it appears to take the most time and be the most difficult, at least with my clients, has been choosing the person to take over those responsibilities as trustee. My sister's always been close to the kids, but she's got kind of a crazy wild lifestyle. And your brother really has never developed. And if we provide him the money to take care of the kids, he'll use that money to support himself and his wife and his kids, and all the issues that are in families. And so people start going through those things, trying to figure out who is the appropriate person and what kind of controls can be put in place to make sure that their desires for their own blood children are taken care of, and those funds aren't benefiting others.
Or, that's absolutely correct. And not just benefiting others, but also they're not squandered in some way.
Right.
Where you want the trustee to invest it prudently so that it has some return on investment, so that its value grows over time, and there's adequate funds available as the child reaches the age of majority to pay for college tuition and things of that nature. So you definitely, the trustee is what the law terms a fiduciary. This is somebody who holds property or has the right to act on behalf of somebody else. And the trustee stands in a fiduciary relationship to the child, to the beneficiary of the trust. And that is, I agree with you, one of the most difficult decisions a parent makes, both managing property and also who's going to be appointed guardian to be in charge of making decisions regarding, the child's health care, where the child's going to live, where he's going to attend school.
Moral upbringing.
Absolutely.
Is this person going to raise my child the same way that I would have raised my child, or at least have similar mores, similar religion, similar fervor in their religion? Do they go to church every Sunday? We do, or is my child basically going to fall away from the church and we'll have to rely on what I've shown them before I pass? Those kinds of things. Those are serious issues. And usually, when I have delays in trying to get estates, set up and planned, the biggest delay is I may go 4 weeks with no activity because the clients can't decide who to appoint.
That's absolutely correct. And our job as attorneys is to counsel clients on the attributes that they need to look for in the person whom they want to nominate to serve in that capacity. But ultimately, as we know, it's the client's decision on who they think is best to serve.
Right. And just as you pointed out a little while ago, a lot of people say, well, gee, I want my mom and dad. I like the way they raised me, and we have a wonderful family home when I was growing up. And so I want them. But the problem is mom and dad are 74 and 75, and they can't really serve that role.
That's correct, or will not be able to do it for a long duration.
Right. Now, something else that we've started doing in a lot of these trusts as we're doing is that we're setting up investment advisors who are another fiduciary under a trust. And you didn't see this years ago, but now, besides having the trustee who is responsible for the trust and the one that really is in control and ownership of the assets legally, but you also have now this investment advisor. And how does the investment advisor play with the trustee?
Well, he would have the investment advisor would be allocated authority regarding making investments. So the trustee is going to actually hold legal title to all the property. That means that all the properties can be titled in so-and-so's name, comma, trustee of this trust. And the trust advisor, the investment advisor, is going to, it depends on how you use the language in the agreement, but the trust advisor can have authority to direct the trustee to make certain investments, or it can be that the trustee is supposed to exercise his own discretion, but to rely on the advice of the investment advisor. It all depends on how you draft the language of the instrument.
Right. And in fact, what we did one not too long ago where it was set up, as you said, the investment advisor was to advise. The trustee made the decisions. But if the investment advisor felt like the trustee was breaching its obligations, the trust actually gave the advisor standing to petition and standing to go to the beneficiaries so that they could petition if they chose to.
And what you're talking about there is standing being the legal right to bring an action in court.
Right. They could actually appear before Chancery or Chancellor and raise the issue of whether or not there's been a breach of duty by this trustee because his decisions or his use of funds or his failure to use funds was such a violation of his obligations that became a breach.
And so you have two issues there, I think. One is you can have a trustee who's authorizing investments which are too speculative. That is, that you're running a too great of a risk of having no return on your investment and perhaps losing the money. You can have a trustee in circumstances where they're investing perhaps too cautiously, where they have all the money in a money market and it's earning such nominal interest.
Or in a checking account.
Or a checking with no interest.
Right.
And so there's no return on the investment. And so there's a balance there. And of course, the investment advisor is there to advise the trustee, here's some safe investments, perhaps high yield stock. All the rave now is these exchange traded funds that everybody's wanting to invest in. But that type of advice from an investment advisor is critical because the average, you or I don't follow the market as closely as somebody who's in the business of investing would. And they'll be able to advise the trustee on the types of investments which are going to hopefully be safe, reasonably safe, but also have a high yield in the long run.
Right. I agree with that. And then I guess the other issue would be who would actually be the guardian. And the guardian would be effectively, in most cases, where the child lives.
That's correct. And the guardian can be the same person as a trustee. Doesn't have to be. You can have a trustee over the property, one person named to serve in that capacity, and another person served to be over the guardian. Obviously, they're going to have to work together because a trustee very likely is going to have to use some of the funds to help supplement where the child lives, because the guardian presumably is not going to have sufficient independent resources to take care of the child.
Or even if they did, chooses not to use their independent resources to raise another child that's not theirs.
That's correct. So the trustee would then be in a situation where he would be providing the guardian some amount of allowance to help take care of the child.
Right. And I know then you get into issues, for example, I'm aware of a guardianship where funds, when the mother was passed, the funds were provided to the grandmother, the mother's grandmother, who was a great grandmother of the child, to take care of and to raise the child as best could. And in the course of time, that child began to need laptop computers for school,
right.
Needed additional items for school because now our schools are driven by technology. And so they have to have they even have to have cell phones that are smartphones now, so that they're aware when a teacher sends them an email if they're not at their desk. And so great grandmother didn't have the funds to do that, nor did she have the capability of choosing what needed to be done. And so we actually had to take steps to assist her in making those decisions for the ward, basically the child that was being taken care of.
And those are situations where, so when the parents are planning and they're discussing whom do I want to nominate to serve in this capacity, those are the types of questions that they're going to consider. Is, who, perhaps the great grandmother's not the best situation to know those types of things, but they may have a close friend who they trust implicitly. And that's ultimately what I think the probably most important consideration is. In whom would you have the most trust and confidence to act in that capacity to take care of your child? And that's the person you need to consider. And sometimes people come in and see me and they think, well, I don't want to hurt one of my family members' feelings. And I tell them, particularly in the context of a testamentary instrument, it takes effect only upon your death. So at the time this is effective, you're not going to be around. So your primary focus needs to be not on protecting the feelings of your family, but needs to be on doing what you think is in your child's best interest.
Right. And the other thing that so many people forget is that estate documents are living, breathing instruments. Until your death, they are modifiable. And so, the situation today with respect to who you choose and who would be best for your child may change 5 years from now. It may change next month, and so, as things occur, it is not inappropriate to make the changes that you feel are needed to address the change in the landscape in your family.
Absolutely. And so that's one of the conversations you also have after you execute either a testamentary instrument like a will, last will and testament, or a living trust that you always have with the client is, if your circumstances change or anything, what you've planned today, you want to make something different, call me, come back. We can either amend a trust, we can execute a codicil to a will, or we can just start from scratch again if circumstances change to the extent that your entire estate plan needs adjustment.
Right, exactly. And so that's something that we always have to address with them as they're leaving. And I agree. And in fact, I've had situations where we've done documents and without the ink even getting dry, I get a phone call the next day. Oh, we've made a change. And so literally in one estate situation, we made 5 changes in the period of 2 weeks before we finally finalized the documents, because while they had gone through the process of making the decisions, they were close calls. I mean, it was a good family, and so they were good people, but there were just different issues that were still weighing on our clients. And so during that period of time, once they saw it in writing and were able to sleep on it, it caused them to rethink. Right. And rethink.
Reconsider.
Which is fine. I mean, the purpose is to have estate documents that meet your desires for your loved ones and meet your needs financially from the standpoint of taking care of your assets. And so as long as we've done that, I don't care how many times we have to change it, as long as the version at the time you pass is what you really want.
That's absolutely correct. And sort of one of the ultimate issues you talk to the client about is that you want this document to provide for how you presently desire for your property to pass upon your death. And so it's like you said, it's a living document. It's an ambulatory document. It's freely revocable, freely modifiable. So you're not setting anything in stone with that initial estate plan document, but it puts something in place for if something happened to you that day or the next day or before you decide to make changes, you have the comfort of knowing and security of knowing that you have a plan in place.
Right. And you also need to understand that, these documents are private. Now, oftentimes when you've decided to ask your brother Bob to be the guardian or your brother-in-law to be the trustee, you oftentimes you'll have that kind of conversation, but with them to make sure they'll accept that obligation before you finalize your documents. Well, I see we're to the half hour. This is Legal Bytes, Jim McCoon and Trevor Ashley, and we'll be back with you on the other side of the hour after news and a break.
Tennessee Valley's news, talk, and sports leader. Nooga Radio, AM 1240 and 92.7 FM.
3, 2, 1.
Chattanooga Radio, AM 1240 and 92.7 FM's news now.
The city council voted and short-term vacation rentals are no longer allowed in the majority of the city of Chattanooga. A zone called the city overlay has been set up where short-term vacation rentals will be allowed. Those who are operating legally now will be grandfathered in and will be allowed to continue to operate. Those who are operating so-called illegally will be forced to pay a $50 fine every day of operation. The decision passed 7-1. A family of 4 is homeless after a fire broke out at the Bayberry Apartments on Windsor Street. One brave neighbor saw the smoke, ran inside, and warned residents. Chattanooga police doing the same. 6 fire companies responded to put the fire out. Nobody was hurt. A suspect has been arrested after 3 people were shot, 1 killed at the Cityco on Glenwood Drive. Jacoby Jordan taken into custody. Police say the teenager shot 1 man and killed him and then injured himself in the process, taking himself to the hospital. 1 victim died, 2 others injured. Russell Stroud, Nooga Radio News, now.
In-depth traffic, news, and information. Mornings on Nooga Radio, AM 1240 and 92.7 FM.
Expect partly cloudy and pleasant weather out there through your afternoon. Could see a little spotty shower pass through, but not much. Highs 80 to 83. Tonight, clear, comfortable. Some late fog, lows upper 50s. For Wednesday, lots of sun, warmer highs mid and upper 80s. Scattered showers and thunder showers later Thursday. Celebrate the 4th with Dixieland Fireworks. Locally owned with the largest and newest selection around. A Black Cat dealer with the lowest prices in Dixie. Dixieland Fireworks, just off I-75 on Ringgold Road, East Ridge. And I'm Swarm Machine 12 Chief Meteorologist Patrick Ford. On Nooga Radio, AM 1240 and 92.7 FM.
The Tennessee Valley's news, talk, and sports leader. Nooga Radio, AM 1240 and 92.7 FM.
McCune, Williams & Ashley PLLC offers a full array of legal services to meet the needs of businesses and individuals. Our attorneys represent diverse backgrounds, interests, and legal emphasis, but we share one common goal: providing the highest quality legal services to our clients through the combination of our talents, experience, and expertise. In each case, we strive to tailor those services to meet each client's specific circumstances. Business law, business organization, civil litigation, commercial litigation, conservatorship and guardian law, bankruptcy law, just to name a few. With over 188 years of combined experience, McCune, Williams, Ashley PLLC is here to help you and your business succeed. MWALawfirm.com. That's MWALawfirm.com. Call 423-756-6400. That's 423-756-6400.
Picture that curl of steam rising from your fresh-made pizza. And in a flash, let it take you aloft, teasing all your senses. I'm talking about Jet's Pizza. If you eat out at Jet's in Hickson or take home your steaming deep dish square pizza, you'll love Jet's. They use only the best ingredients in a family recipe. Also try the cheesy bread, wings, chicken, or bread with bacon, antipasta or Greek salad. Jet's Pizza at Buy Low near the S-Curves. Open till 10 p.m. Sunday through Thursday and 11 p.m. Friday and Saturday. You can order online or have it delivered. jetspizza.com. That's jetspizza.com. Or call them now. They'll have it ready when you get there. 757-1616. That's 757-1616.
Jet's Pizza, the best pizza in town. 3600 Hickson Pike.
Life is short. Eat better pizza.
Let's get Jets. Hi, this is Nadia behind the green door. You've had ice cream and you've had shaved ice, but have you had snow cream? It is amazing. It's light, airy, fruity snowflakes melting on your tongue. You need to come and see us. Highway 58, green door next to Hardee's.
Nooga Radio, AM 1240 and 92.7 FM knows your opinion is important. So call 800-8949. Agree or disagree. Call 423-800-8949. 800-8949. Nooga Radio, AM 1240, 92.7 FM, and 95.3 HD4. News, talk, sports. Nooga Radio. The Tennessee Valley's news, talk, and sports leader. Nooga Radio, AM 1240 and 92.7 FM.
Welcome back to Legal Bytes, your weekly program with respect to the discussion of new topics in the law, legal issues that affect your lives, both in your business and in your personal lives. And today we've got Trevor Ashley with us, and we've been talking about how summer vacation and trips abroad and the like have caused a spike in the need for addressing estate planning issues for various families, especially younger families where we've got minor children in play. And also because I think younger families normally don't think about estate planning documents or their mortality until all of a sudden an event such as an overseas trip or just a trip across country. I know right now, I just read a blog yesterday where they were saying that they were expecting 1.2 million more people this year on the roads during the week of 4th of July than last year. And the reasons why were basically, one, they think the economy is now freeing up people to take trips as opposed to staycations, as a lot of people were doing. And the other reason is simply because people are afraid to travel abroad. And so they're looking more within the borders of the United States for their holiday trips. And so they're going to be on the roads with the rest of us doing things. So, because of all these kinds of issues, and of course, with that many people on the road, there will be mortality. There will be issues because, there will be accidents involved. And so that's caused, at least in our office, a lot of people contacting us regarding these kind of issues. And Trevor, you and I just finished at the end of the first half of the hour discussing the fact that these are always modifiable, and it's not uncommon to make very hard decisions. And then once you see them in writing and on paper and you think about them, revising that decision. And that's something people should do if they're not comfortable with what they've done.
Well, that's absolutely correct. And also circumstances where you have one plan in place and over time, family circumstances change and you decide we need to make some changes to our plan. And it can be anything from, special provisions for one child, which you think may need more financial assistance after your passing than another, or, in the unfortunate circumstance of divorce or some type of change like that. There's always these circumstances in life are always changing. And with those changes come the need to modify your estate planning documents.
Or something more joyful. We've had more children.
Absolutely. Right. Absolutely.
We have a call. Hold on a second. This is Jim McComb with Legal Bytes. Caller, how can we help you?
Yes. So I can't decide whether to get a lawyer or to just use a form will, which I know some people do. What would be the benefit to, paying the expense of getting a lawyer versus using just a form that I could get?
Well, that's an excellent question. I think a lot of our clients are presented with that exact issue because there's services available online, I think, where people can LegalZoom have a will prepared for them. So a few issues to consider. One is consulting with an attorney. You're always going to have the benefit of talking through a lot of these issues that we've been discussing, like who is the right person to serve as executor, who is the right person to serve as denominated as guardian or as trustee, and also talking through exactly what type of provisions to include for the proper care, maintenance, education, and support of the beneficiaries, the children that you're taking care of under your will. Secondarily, and probably at least as equally as important, is the law provides very strict requirements for the proper execution of a will. And the law is very strict in requiring that these formalities be followed to the letter of the law. And if the will is not executed correctly, it will not be admitted into probate and will not be enforceable and will not take effect upon your death. So I think those two primary issues are good reasons why people should consult with an attorney.
Well, also, I think looking at the complexity of your estate, I don't know anything about you, caller, but depending upon, how many children you have, the needs of your children, are they divergent? Are you in a modern family where there are stepchildren and blood children involved? And how do you address that? Is there going to be a need for a trust internally within your will? Or are you going to have any type of an arrangement to take care of issues that need to be addressed for a minor in your will? Tax ramifications that may arise depending upon the size of your estate. There are numerous issues like that yes, you can use a form will. In fact, in Tennessee, you can do what's called a holographic will. You can actually prepare a handwritten will yourself. But as Trevor indicated, the big issue becomes whether or not you can, at your passing, have that will actually probated and approved by Chancery Court here in Hamilton County or in any state in Tennessee, county of Tennessee, because of the fact that, if you don't follow the formalities, then the will can't be proven up and admitted to probate, and letters testamentary can't be issued.
That's absolutely correct. And consulting with an attorney, you get to address all those issues, make changes to your document as you're considering these various factors. And so overall, I think you have a much more comprehensive plan in place by consulting with an attorney, and more certainty that the document is going to be effective upon your death than you would if you utilize one of the services online.
Right. Did I answer your question?
That did. Thank you all.
All right. Thank you. All right. Now, Trevor, we're talking now. There are other things besides the will and possibly an internal trust that we need to address when a client contacts us about, especially a younger couple contacts us with respect to the needs to travel and what should happen. And one of those first issues arises is, what if you get very ill and something happens? Maybe you're in an accident overseas and you're brought back into the States, or perhaps you're in a situation where you become very ill and because of some rare disease get into a disability such as a coma. How do we address that for the client? And what instruments do we want in place to try to address that so that they're still able to have things that are necessary regarding their estate handled while they're in this situation?
Well, the simplest mechanism is the use of what are called powers of attorney.
Okay.
And there's, sort of broadly speaking, two forms of a power of attorney. There is a financial power of attorney where you authorize someone to act for you to manage your property. And there's a healthcare power of attorney where you authorize someone to make medical decisions for you. And both, just like a will, powers of attorney generally are revocable, assuming you have capacity to revoke the document.
To revocate.
But the key is, again, nominating or authorizing someone in these documents in whom you trust implicitly, you have the utmost trust and confidence to act on your behalf with respect to financial matters and healthcare decisions.
Right.
And that person, so in the event of your incapacity, let's say in your hypothetical, you've been in a car accident, you're hospitalized, you're in a coma, the person you've authorized to act in the power of attorney then can step in and exercise their authority to manage your property and make healthcare decisions. And they're, again, standing in a fiduciary relationship. So their objective is to always act in your best interest.
Right. And they don't have to be the same person.
That's correct. So you might nominate one person that you trust with your financial decisions to one person, and then another for your healthcare decisions. A lot of times with spouses, each spouse first nominates the other to serve in that capacity, but then the spouses can choose also whomever they think would be best in that position.
Right. I know I've recently handled an estate session where husband was put over the finances and had the durable power of attorney, general power of attorney, with respect to the issues for the wife. But the oldest child, who was an adult, was given the healthcare power because actually husband thought that it was better for family harmony if they got into one of those situations to have her firstborn, who's an adult and was well thought of in the family and was certainly very mature, to have him hold that power if we got into a life and death situation, such as withholding sustenance, pulling the proverbial plug and letting someone just go into the afterlife, that it was better for the child to make that decision than the husband.
It sounds like from what you're saying, I assume this was a blended family.
It was.
where the wife had children from a previous relationship. These are the most, there's lots of very personal decisions one makes in his or her life, and end of life decisions are some of probably the most personal. And there's a third instrument where you can actually manifest, that is, make known your intention in the event that you're in some sort of catatonic state where you're not responsive to any stimuli, and doctors opine that that they can state to a reasonable degree of medical certainty that you're not likely to recover. And that document is called a living will,
right,
or an advanced care directive. And the idea is, while you're well now, sitting here talking, you're going to make decisions for in the event that you are subsequently in one of those conditions. And so probably the best example of a situation where there was not this type of planning in place is that Terry Schiavo case, you may remember, from the state of Florida,
right,
where a woman was in a catatonic state, and there was a dispute between her parents and her husband as to whether to essentially withdraw artificial food and water and let her pass away. And ultimately, the courts got involved, and that issue was resolved. Had she had planning in place with a living will, she could have manifested that in a legally enforceable document, where then there's no dispute as to what she wants to happen in that circumstance.
Right. Now we're going to get to a point where insurance is going to step in at some point, I think, and say we're ready to pull the plug.
Well, and that's particularly private insurance, yes. And a lot of those cases, ultimately, medical care is provided through probably a state version of Medicaid.
Right. Exactly. So, as part of when you get contacted by a young couple that's about to do something like this, go on a trip and the like, and they said, we've never had any documents done, and we really feel like we need to, we've got 2 at home, maybe even have 1 in the oven at the time. And they said, we just want to make sure everybody's taken care of. So you go over at that point, the will, and trying to have will, and you try to have a will for both of them. Even if one of them is not a breadwinner in the home, you still need to have a will.
Oh, absolutely. Yes. And a lot of times married couples have what are called reciprocal wills, where they have provisions where first each leaves everything to the other. And then the event that they don't survive one another, they provide for dispositions of their property with the same provisions, essentially going to, nominating guardian and trustee and that type of thing.
And so, and then you also suggest that they have a healthcare power of attorney.
Correct.
That they have a general and durable power of attorney. And durable means it survives and still effective if you're disabled and incompetent.
That's correct. Yeah.
Right. And then the last thing is you're saying we need an advanced healthcare directive to address end of life issues.
Correct. And I can't stress this enough, that there's 2 real benefits to an advanced care directive. One is that the client gets to manifest what their intention is while they're able to say, in this circumstance, this is what I want to happen. That's important. It's also important too, the person making the decision has certainty as to what the family member wants to occur in this circumstance. So the benefit really is twofold. It's you get to tell everyone, if I'm in this health condition, here's what I want to happen. Second benefit is the person making the decision now gets to rely with certainty that they know they're making a decision that you would have wanted made.
Right. All right. Now then, let's assume all this documentation is done, and it may be done on short notice, like my situation a couple of weeks ago was, where you get it all done in 5 days. And then really there's a couple more things that need to occur. Well, one is they need to advise someone what they've done and where their documents are, other than their attorney, because their attorney may not be in social circles where they're aware something has happened.
That's correct. A lot of times, during the consultation, we will note in the file where they plan to keep their original documents.
Well, that's the other thing is we need to make sure someone knows where the documents are.
Absolutely. And a lot of times the couple we advise people, for example, in the will, to tell the executor, the person they've nominated to serve as executor, where the original document is. And it needs to be somewhere safe. It can be in a home safe, or it can be in a safe deposit box at the bank. People ask me sometimes, well, if it's a safe deposit at the bank, how will the executor get it? Well, what you do is you provide a copy of the will to the executor, and you put the original in the safe deposit box. We have a statute in place in Tennessee where the executor can take a copy of the will, show it to the bank, and then the bank is authorized to allow you access to the box to retrieve the original will. You can't take any other contents, but you can take the original will, so then you can take it to court for probate.
That's interesting. That's a well thought out statute, isn't it?
It is, yeah. Not all of our statutes have that much common sense, but that's a very common sense statute.
Right. So we make sure someone knows that instruments have been prepared, and that who the attorney is, so that someone can contact the attorney. If, a lot of times our clients will have us hold the original documents. And then the other is to let them know where the documents are.
Correct.
Whether, and as you said, it's oftentimes provide a copy. I know I've got a lot of clients that don't want to provide a copy because they don't want their decisions known while they're still around.
So that's a very important point. Probably the best way to address that concern is for your client to tell whomever they've nominated as executor that person has been nominated as executor under the will, and that tell them who prepared it, that Trevor actually prepared it and he has a copy of it. If something happens to me, contact him and he will get you a copy so that you can access the original in the safe deposit box.
Now that's a good point, Trevor. How would someone contact you?
Well, thank you for asking. I'm an attorney at McCune, Williams, Ashley, and Stanley, and our telephone number is 423-756-6400. And hopefully the listeners have picked up that we frequently advise clients on these types of estate planning matters. And for any listeners out there that are interested in learning more about the topic, we would certainly be happy to set up a consultation for you.
All right. Now there's a last issue, it seems to me, that's important, and that is, funding all of this. And that means insurance. And usually there's life insurance somewhere in place. And if we get into dual disabilities, say both individuals are hurt or one is killed and the other one's in a coma, we need to know where medical insurance is. So we need to have access to life insurance and health insurance for the person who will be taking over the estate or may hold the durable power or maybe the alternative attorney under power. And so that information has to be gathered. And I know oftentimes I suggest to my clients that they actually put together a notebook.
Absolutely.
And
yes.
they list, the documents that are material. They maybe put in copies of the life insurance and medical insurance policies and card information into the notebook, that they provide contact information for the attorney, for the insurance agent, for maybe the investment advisor if they have investment accounts and the like. And they may even put in a copy of the last statement at the time they're preparing it, for any investment accounts or bank accounts, so people have access to account numbers and can access, going through hoops, of course, getting authorized, but can access that information if needed to take care of either the individuals if they're disabled or to attend to the estate and take care of minor children and the like.
That's absolutely correct. And I've actually been involved in cases where a person lived by himself and died and had family out of state, no children. So his natural heirs were his siblings. His parents were deceased. And they asked us to serve as the administrator of his estate. And one of the first things we had to do was try to discover what he owned at his death. And it involved writing letters to financial institutions. And he held a lot of stock certificates, individual stock certificates. So there, it wasn't like at a brokerage with book entry shares. It was, he literally had certificates, many of which had been, they'd split over time. And so that stock certificate actually represented more shares and it was on the certificate itself. And it created a huge situation, a ton of time having to go through and try and find all of his assets.
So putting together this type of information and actually I had them provide one for us to hold in their file for them and one that they put in a common place where they knew that their future fiduciary would know how to access the information. And that way, people were able to avoid all that. And I will tell you, just as a side note, in doing that investigation of assets, don't forget to look in unusual places, because I know I've had this situation recently where thousands of dollars were found inside pictures hanging on the wall, in the backs of photographs or in the backs of prints. This is Jim McCoon with Legal Bytes. Thank you so much for spending your hour with us today, and we'll visit with you next Wednesday to discuss additional issues in the legal arena. Thank you.